Recently, the High Court of South Africa handed down its ruling regarding the legitimacy of cannabis private clubs in the country. Today, we have on legal counsel that's going to help us unpack exactly what the ruling means, not only for the clubs, but for its members. In addition, what steps need to happen next with regards to cannabis private clubs. Hi, awesome. Today we're going to unpack the Haze Club ruling that recently came through. And we're going to have Paul Michael Keichel from Cullinan and Associates on, as well as Andrew McPherson from Brink to really unpack what's happening in this instance. And on that front, guys, welcome.
Thank you, Jeff.
Awesome.
Hi, thanks for having us.
Cool. So I think for Andrew, let's go straight to the context. I mean, why does this case exist? I mean, recently there was a ruling handed down from case, I think it was 2101 from 2021. Can you give us a bit of scope on, what was basically handed down from this judge?
Yeah, so to start at the beginning, we have some clients that run a grow club, obviously the Haze Club, and that was, in our view, one of the better run clubs. They were registered, paying tax and all sorts of things. They got raided, and we then needed to obviously take steps to keep them from going to jail. And it also represents a wonderful opportunity to try and, to not necessarily to make some law, but to at least punch some holes in some of the existing law. So the way we went about it was we brought a two-part application in the High Court. One was to stay the criminal prosecution pending the relief sought in the High Court, which was the Part B of the application, which is also divided into two forms of relief, but the main one being to ask the court to confirm that the Grow Club models as they stand, or at least the Haze Club's version of those models, fits directly in accordance with the existing law, but also within the precepts of Prince 3, the court judgment in 2018. And then our alternate relief was to say, well, in the event that, if we fail on that, if you're saying that the model does not fit within the existing laws, well, then those existing laws must be unconstitutional, because this is a law of general application that we can see from obvious examples is not available to every single person in the country. And as such, it's discriminating against those people on protected grounds, for example, socioeconomic status, their bodily ability, in the case of paraplegics, people's freedom to choose employment of their choice, you're a doctor working double shifts. So for these people who don't have access to the ability to cultivate cannabis at home, or for whatever their reasons are to not have it, they prefer to go through a grow club, which offers a safe and quality controlled version of cannabis. And and that's what brought us before the court. Originally, it took us a while to finally get heard. We were heard in June, and then we got this disappointing judgment in the last week or so.
Okay, great. Yeah, I mean, we're going to unpack this. I mean, there's certain remarks, comments made in that judgment. Before we get straight into the judgment, I mean, let's go to Paul Michael quickly in terms of, back to the Constitutional Court ruling. I mean, just explain that aspect around privacy, because I think it often is misunderstood by the general public. What actually did that Concord ruling enable? And then, we can highlight the deadlines. But I mean, it's well past. I think we're approaching 4 years since a 2-year deadline was given.
Yeah, Jeff, I think that the 18th of this month, in fact, the 18th of September 2022 is the 4-year anniversary. And what the court did was it hung its hat, the Concord hung its hat on the right to privacy, which it said was unlawfully or unconstitutionally infringed by certain degrees of prohibiting the possession and dealing in of cannabis, insofar as it related to the right of an adult to cultivate, possess, and consume cannabis in a private space. Now, what this really all comes down to fundamentally in respect of the Haze Club judgment is an interpretation of what is a private space. The Concord didn't put a strict definition or a strict constraint on what is a private space. In fact, it takes more the approach of, the various layers of an onion. You have the very core private spaces, being, sitting alone in your own home with nobody who can see you, all the way to the complete outside where you find yourself in arguably public space. It didn't say that you were limited, though, to cultivating, consuming, and possessing cannabis at your home. In fact, it acknowledged that there were going to be private spaces outside of your home. Call it in your pockets or your backpack when you're moving through public In fact, the South African Police Service via a circular even acknowledged that you could put cannabis into your stowaway luggage and allow baggage handlers to handle that when you're flying from Johannesburg to Cape Town. So that's the one aspect, which was around privacy. And then also there was the definition or the prohibition on possession of cannabis was deemed unconstitutional. And now we're in this debate as to whether that extends in respect to the Haze Club to outsource that right. You know, can somebody else possess cannabis for you when they are cultivating your cannabis for you? So when that gardener waters your plant in your garden, are they in possession of that cannabis, and is that unlawful? So that's really the interrelationship between the two.
Okay, I mean, yeah, so I think at this point, let's get into some of those, what was in that actual ruling, because I mean, it seemed very literal. A lot of the examples that were taken, like, especially around, cultivation practices. I mean, often you would see a couple where the husband would maybe be the primary person cultivating, and then he's out for work, and then the wife would cultivate, or, take care of the plants. Now, all of a sudden, it's like, whose plant is it? So, to what extent is that their plant? Because it seemed like the definitions the judge was putting forward was very your plant, your space, and that's not how the world works. It's not how society works. So I don't know, Andrew, if you maybe have some comments around this very narrow definition of private, because, I mean, no couple or family that's cultivating, or bunch of roommates, for instance, that are all lodging together, they're not going to be necessarily be like, no, don't touch my plant. They probably will at some points. But if they're away, they're going to be, please touch my plant. I need some help. I'm traveling. Yeah.
Now, the interpretation that the courts offered is essentially that the end user of the cannabis must be the cultivator of the cannabis. And that creates some patent absurdities, such as, for example, if you are a paraplegic or if you are in any way incapacitated and cannot grow your cannabis, therefore, according to that interpretation, you're therefore barred from accessing your right to use cannabis at home. If you cannot grow it, you cannot use it. The court makes some rather strange remarks on that basis, with regards to, taking the transmission of cannabis from the Drugs Act, which is outlawed, and saying, well, it's not allowed that you can transmit these things. And therefore you must be using cannabis where you're growing it. And we know that that's not in keeping with the Prince 3 judgment. So you're going to be in a position then when you've got, for example, a garden at home where you've got a cannabis plant or two, and then you've got a gardener, as Paul Michael said, attending to your garden, and he's splashing water on everything, and he splashes some water on your cannabis plants. And in accordance with the definition of cultivation, which is also very broad, it essentially encapsulates any process in the growing of a plant. To take the example to its illogical conclusion is that gardener is now guilty of dealing in cannabis and is subject to all the penalties associated with that. And that's just, it's just unthinkable. And the idea that, to go back to the idea of a paraplegic, they're now being prejudiced and discriminated against on the basis of their bodily ability. And by discriminating that basis, that law must therefore be unconstitutional. There's an obligation then on the state, or at least in this instance on the court, to do what we call a justification or limitation analysis. And that is, where you weigh up in terms of the Constitution to say, well, there's been a limitation of a constitutional right here. Then the onus shifts to the state to say why that limitation is justified. And that includes, an evaluation as to whether or not there's a less restrictive means of achieving the same outcome. And that arguably is absolutely possible by means of allowing for a collectivized or socialized growing method, be that community gardens in underprivileged areas, or be that through a grow club for people who can afford it, or any sort of thing in between. And that's, in my view, a very simple solution to this untenable interpretation of who can cultivate and use cannabis.
Okay.
And Jeff, if I can just supplement that a little bit, because I absolutely agree with it, what Andrew is saying, but just to go back to one of your previous questions, the concept of joint co-ownership. So, for example, if that husband and wife jointly co-own the house, they can jointly co-own the garden, and for that matter, they can jointly co-own the cannabis. And it seems to have been only a controversial legal concept when it comes to jointly co-owning cannabis. And similarly, it wouldn't matter in terms of the law if that husband and wife didn't in fact own the house, but rented it from a landlord. But again, on the strict interpretation of the judgment, if I am the landlord and I know that husband and wife are jointly cultivating cannabis in my garden on a strict interpretation of the judgment, I'm also a drug dealer now.
No, that's the thing, and it creates all these scenarios because you think like, what happens if they get divorced and they start bickering about whose plant is whose plant? I mean, now that becomes an issue. The other issue I can see is, for instance, what if the wife is completely opposed, but the husband or whoever partner in this case says, "But I do want to." Now their rights are also to some degree infringed upon. I mean, it creates all these scenarios where that person might say, "Well, I'd rather just then go to a grow club." Because the option exists to then look to do that if it's like impedes me from maybe doing it at home. So, I mean, there's all these kind of to be made examples, and I think it read very narrowly in that sense. But I kept seeing this reference back to the Drug Act. And I mean, there's still much to be desired in terms of amendments around the Drug Act. Can we maybe just unpack, what should be written into that space or hypothetically put down so that we can, I know there's a lot to be said, but it is a little subjective. But I mean, if we keep referring back to an act from 1992 that is supposed to be amended and hasn't been amended, like, what are some sensible amendments that could alleviate some of these issues?
There is a lot to unpack. I'm going to premise this whole thing by saying that Section 1A of our Constitution says that we are supposed to be advancing, not preventing human rights and freedoms. And as Andrew touched on, if the answer is going to be no on the advancement of human rights and freedoms, and you're going to try to limit those, you're supposed to, as the state, have a bloody good justification for doing that. Society is going to collapse or unacceptable harm is going to befall individuals. Therefore, we are legitimate in saying no to this. The Drugs and Drugs Trafficking Act is outdated. It's apartheid era legislation, and it's apartheid era legislation that in fact it has its history even before the war on drugs, because I always go back to that. It was South Africa who, I think in 1912 or so, or 1922, wrote to the League of Nations and says, well, while you are internationally proposing to ban opium, you also need to do this in respect of cannabis. So a lot of people don't realize that it's actually our fault, or at least the initial ban was our fault. So there are many things that we can do to the Drugs and Drugs Trafficking Act. I propose that it requires an entire overhaul, not limited only to cannabis. But short of that, there is this mandate in terms of the Constitutional Court that we do need to allow for the personal and private use of cannabis. One of the interim measures that we can take is to amend the definition of cannabis in the Drugs and Drugs Trafficking Act, because it's so broad. It talks about the whole plant or any portion or product thereof, which means that you're dealing with the seeds, you're dealing with the roots, you're dealing with all of these non-psychoactive components of the plant, which means how is it that you are supposed to get your hands on cannabis seeds in order to exercise your constitutional right to grow cannabis, if the law says that would be illegal drug dealing? There are all of these absurdities. So one could start by amending the definition of the Drugs Act, or the definition of cannabis, and then that would buy us the time to negotiate with government, and for government to engage with the various experts and to draft an overarching piece of cannabis legislation or drug legislation that addresses all of these absurdities and all of these outdated apartheid era laws.
Yeah, 100%. So, Andrew, on this front, I mean, I'm going to open it up to you to maybe if there's additional comments you want to make about the ruling, but I also want to ask beyond just those comments, like, what's the way forward here? Because obviously an appeal will be heard. And then obviously if it's not successful, then it becomes very questionable in terms of like what happens to these private clubs and their members going forward. So I'd like to unpack that, but maybe you got some additional comments before we unpack, potential of like the future of private clubs.
Something else to consider is that, just to go back to my earlier comment and Paul Michael's comment that, the state has to have a bloody good reason if it's going to limit constitutional rights, is that there is a very easy way to do this. And it was actually referred to in the Prince 2 judgment, which is that by regulating the industry, which is not as difficult as the state makes out in its papers in the Haze Club case, because we see this, with its regulation with issuing licenses with regards to, research permits and export permits and all these sorts of things, which also takes care of a lot of the arguments is what if this happens in a growing environment? What if this happens? Well, it's equally applicable to something you've already said is fine, which is a licensed operation in terms of the regulation. So it's unclear why, for example, like a new category cannot be created, which is for grow clubs or something similar to that. the capacity is there, the infrastructure is already in place, and that would constitute a far less restrictive means of allowing for people to exercise those constitutional rights. Where to from here is to continue fighting for those constitutional rights and to take it onto the next step. The legal team's busy discussing the actual drafting of the application for leave to appeal. That's in the pipeline. It's got to be filed before the 19th of September, which is just under 2 weeks from now. Once that's filed, then the next steps will be taken to get the matter before the Supreme Court of Appeal, which we're hoping, on our sort of preliminary timeline, we've calculated that we'd hope to be heard before the end of next year. Obviously hoping for quicker turnaround, but we've got to be realistic with a pretty congested court system thanks to COVID and other things.
Okay, no, 100%. I mean, you're right. I mean, we think of Canada that has a regulated federal system. They got Uruguay. Thailand has got their medical definitions, but it's thrown it out with the kitchen sink. It's pretty much a bit of an unregulated market. But I mean, it's all about, going against the INCB, UN, 1961, even older laws. I mean, there is a need for more nations, and this is what Germany's trying to dissolve, is, how do we enable some commercial transaction for responsible adult use outside of scientific and medical purposes? Because I think that's where the trick comes in, is like migrating it beyond the scope of the UN definitions for how narcotics are handled. And it isn't that complicated. At the end of the day, there are examples where this has been done successfully, and it will continue to be a major global issue. And like you said, a controlled environment for cultivation increases the quality of those products and the safety of those products from heavy metals, pesticides, aflatoxins, whatever might come across it. And that's in the best interest of the public. Yeah,
it's a really important topic, and that's something that we've seen in the state's answering papers. In our case, in the THC case, is that they seem to follow this argument that one can simply throw a seed in a pot plant and put it on your windowsill or your backyard in a township and grow your cannabis. But we all know that that's not really how things work. They dismiss the argument that there's specialist knowledge or tools or anything required, basically implying one can grow the seed on your windowsill. But that said, when we look at the state, what the state's saying out the other side of its mouth, when we look at the National Master Plan, or we look at even there's a website up with a government-based institution intending to, I'm not sure if it's up and running yet, but to train communities and especially traditional farmers, to try and bring them into the formal economy by educating them on what they need in order to meet regulatory thresholds and things like that. And that's implying, you need to be trained. You need to have access to certain materials. And then on the other hand, you've got the state saying to us, no, just throw it in the ground. You wouldn't say to someone, a drinker, you wouldn't say, go brew your gin in your bathtub. You wouldn't say to somebody who smokes cigarettes to go and grow their own tobacco. We know that these processes aren't safe. And if they were safe, we wouldn't be sitting with all these regulations governing their manufacture and sale and all of these things. So it's unclear why we're making this big fuss here. It's clear the state is even saying you need to be educated. There's a process in place, but we're kind of dealing now with in litigation. The state's obviously bound by existing legislation, despite even this draft private purposes bill now having comments saying maybe we need to make allowance for the future commercialization of recreational cannabis in other legislation, but God only knows how far away that might be.
No, thanks for that. Yeah, fully. I get those sentiments as well. There is specialized knowledge, and if we are trying to create 130,000 jobs, like is stated in SONA, then surely those jobs would require some degree of skill and upskilling to really be successful careers for people to pursue meaningful jobs, not just putting pot plants out in the sun. I mean, there's a little more nuance to this, and I think that to just downplay it is being somewhat dismissive of an entire industry that's got hundreds of thousands of jobs globally and highly specialized jobs at that as well. On that, Lars, I want to wrap up maybe with Paul Michael in terms of civil society. I mean, it almost feels like we're very much back in 2018 fighting for some kind of developments on this front. I mean, should civil society be getting more active here? Because it just doesn't feel like there's a degree of maybe respect for timelines in terms of what we see. Yes, COVID did happen, admittedly. But, I mean, it's 4 years almost by the 18th of September. I mean, it does feel that, yes, this is an aspect of legislation and policy, but we find ourselves back in the judiciary because we're just not seeing that effort made on policy to change things.
Jeff, it's twofold. It's not only government in action that we should be protesting here. You know, we ought very soon to be taking to the streets and letting government know what our opinion and what our needs, wants, and desires are. But it gets worse than inaction. The elephant in the room in this matter is why hasn't government capitulated to this matter? There was nothing that stopped it from doing so. It didn't have to fight this matter so hard. When it came across the desk of the state attorney and ultimately senior counsel, they could have looked at this and they could have said, hell, this is actually a really good way of minimizing the harms of cannabis and allowing the progressive realization of human rights that were hard won in the Constitutional Court in 2018. Instead, I don't know who, and I don't want to defame anyone in the process, but I can only think that you've got a very, very conservative prohibitionist decision maker sitting somewhere saying, no, absolutely not. We're not going to yield. We're not going to give any quarter. And if and when we make the decision as government that we are going to afford our citizens human rights, well, then that's when we're going to do it. And in the meantime, we're just going to fight, and we're going to fight hard. And I don't understand it. And this is something that I think is worth taking to the streets.
Yeah, fully. I mean, agreed on that point. It's time for there to be policy reform, and I think global sentiment about all drug policy reform is definitely been a central topic and will continue to be. So, Andrew, Paul Michael, thank you so much for your time. Really appreciate it. Thanks for giving us a bit more context regarding the recent decision making around the Haze Club ruling.
Thanks very much, Jeff.
Thanks, guys. Thanks, Jeff.